Good night. Did you see what is going on regarding Sergeant Bryan Fahey of the Connecticut State Police? It's concerning. My husband was listening to something chaotic earlier this week, and even though he had his headphones in, his earbuds, I guess they're called, I could still hear it all the way across the room. And it turns out that it was some sort of altercation between a state police officer in Connecticut and a YouTuber. Um, I don't want to rile you up by playing it here, but I will link the footage in the description. And instead, let's take a look at an article describing what this officer, this trooper, has done most recently. And then we're going to take a look at some of his previous conduct because this guy is a problem. Okay, hopefully you guys can see this all right. It's an article from patch.com. I tried to choose an article that had the least amount of like flashing and animated ads. So, okay, it's called New Details Released in Confrontation Between YouTuber and Trooper in Groton. Groton is a town in Connecticut. It's a coastal town. It's where the sub base is. If you're local to the New England area, you may have taken field trips to go on a submarine, back when you were in school. I know that's something that I did growing up there. So Groton, Connecticut, it's Groton, New London. It is all, let's see, uh, kind of closer to the Rhode Island side of Connecticut. Okay. So a content creator showed up at a state trooper's home to question him. The meeting quickly became heated, and the trooper retrieved a GUN. You never know what YouTube's going to freak out about in terms of words. So let's see. The article is by Chris Radigan, a staffer with the Patch News, and it was posted Tuesday, July 15th, 2025, and was updated a short while later. So, new details have been released after a New York man was arrested following a confrontation with an off duty police officer. Groton, Connecticut. New details have been released after a New York man was arrested following a confrontation with an off duty police officer at his Groton home regarding the officer's overtime pay. SeanPaul Reyes, 34, of Gorham, New York, who calls himself, quote, an independent journalist and constitutional activist, end quote, is a YouTube content creator. His channel, Long Island Audit, has 948,000 subscribers. Reyes and his cameraman, Tahim Glover, 20, of Selden, New York, went to the home of an off duty state police officer on Friday. The officer has been identified by Reyes and in media sources as Sergeant Bryan, and that's Bryan, Fahey, Fahey. Reyes said in a statement he intended to exercise his First Amendment right to ask Fahey questions about his overtime. Reyes, quote, arrived at the home with a box truck playing video footage of a prior interaction between the parties, end quote, according to police. Reyes' video shows him in front of the box truck's enormous screen outside the home's driveway. Reyes walks up to the home and rings the doorbell. Fahey answers the door and tells Reyes to leave the property. Fahey then goes back inside his home, and Reyes and the cameraman begin walking away. Fahey then comes back out of the home with a hand GUN at his side, the video shows, shouting at Reyes to get off of his property. In a statement, Reyes said, quote, on several occasions, Sergeant Fahey obscenely cites his authority within the Connecticut State Police, end quote, as he moves toward Reyes, and at one point, Reyes claims, spits in his face. And I watched the incident. I mean, that's what happened. I will link it for you in the description box so that you can see. Town of Groton police responded to the incident. Police confirmed that there was a verbal confrontation and the off duty officer retrieved a GUN. Reyes and the off duty officer have an ongoing civil litigation, according to police. Reyes and Glover were charged with, now remember, these are the people that did not have the GUN, okay? So Reyes, the journalist, and Glover, the cameraman, were charged with second-degree breach of peace, first-degree criminal trespass, and voyeurism with malice, according to police. Reyes and Fahey had previous history, including a confrontation in 2021, so 4 years prior, when Reyes claimed he was, quote, unlawfully detained by state police for filming at Bradley International Airport. Bradley is the airport that's like just outside of Hartford. It's the main international airport for the state of Connecticut. He also posted a video depicting a prior run in with Fahey in 2023. My word. So they actually have two previous um, bad interactions. The State Department of Emergency Services and Public Protection declined comment on the case. The department confirmed on Tuesday to Patch that Sergeant Fahey is an active member of the Connecticut State Police and is not suspended, nor is he on administrative leave at present. Groton Police said in a statement that this is an active investigation and that there would be no further comment. All right, so that is the article giving you the overview of what happened. And like I said, I'll put the link in the description box, but trust me, like you're gonna like keep your volume down on it. It's extremely chaotic. If you have experience with if you have experience with DV from a previous spouse or something like that, uh, it is going to be very, I don't want to say triggering, but let's say activating. Okay. So just really be mindful before you watch it because it's very intense. All right. So my understanding is that Brian Fahey is already in a desk duty administrative role. And I think whatever it is has to do with registering firearms. It was implied that this is because of his prior conduct. The journalist, Sean Reyes, was curious how someone working in a 9 to 5 administrative role could accrue such substantial and consistent overtime, hence the visit to Fahey's home to request comment. And when we look at the payroll details year over year, like I have it pulled up on the screen, I mean, it's certainly a valid inquiry. According to this chart, some years, Fahey has nearly doubled his income via overtime. It's also interesting to see that Fahey is earning 4 times as much now as he was in 2010. That's 15 years. I mean, is that a reasonable increase? When I started teaching in public schools, my salary was $35,000, and at the time, that was good. Can you imagine 4 times that amount? I don't think that there's a teacher in the whole state of Texas that is earning $140,000 a year. I mean, unless I am seriously out of touch with reality. And so you can see how this pattern is worth exploring. Such dramatic overtime could point to a staffing issue amongst, many other things. And if this sergeant was truly reassigned to desk duty because of conduct, which would not surprise me at all given how reactive and just aggressive he is, then surely he has no business doing duties beyond the scope of his desk job that could pose a risk to the public. I mean, this guy has like unbridled aggression issues. It's concerning. So, okay, when we look at this, the light blue here is the overtime amount. The dark blue is the base pay. And the reason that 2025 is as stubby as it is, we're only midway through the year. So that's how come it's reading the way that it is. And as I was going through these records ever so slightly, these are his paychecks, like pay stub by pay stub for 2024. And when you start looking at it, and they unfortunately, I don't think, yeah, these aren't dated, so I don't know which is up and which is down. But um, it starts out with a salary of, let's say, 7,400, 7,500, and overtime of 2,400. But then as we move through it, the overtime pay starts like really getting more and more significant to the point where these two numbers are nearly matched. Um, so we have 5,400 in base and then 4,600 in overtime, 4,900 in base, 27 in overtime for one of his paychecks, 49 in base, 21, but then it increases again. 49 in base, 4,200 in overtime, 49 in base, 4,000 in overtime, 49 in base, 3,400. So, I mean, I think that Sean Reyes is perfectly within his rights to sense that something is wrong. And as a journalist, he has the right to explore it and to research it. Now, he has a fundraiser. Let me see if I can pop that up on the screen for you. So, this GoFundMe will hopefully help us to better understand what SeanPaul Reyes's course of action is going to be. So, it's titled Help Me Fight These Unlawful Charges and Injustice. It has a $40,000 goal, and it is currently at 38,860. And wow, somebody actually gave $1,000 toward this. That's fantastic. Okay, so Sean Paul writes, fellow patriots, freedom isn't free. This isn't just about me. It's about a corrupt system that uses the legal process itself as punishment. They want to financially drain me with excessive bail, legal fees, and endless court battles to stop me from holding them accountable. On Friday, July 12th, while peacefully exercising my First Amendment right of freedom of press, I think he means I was unlawfully arrested by the Groton Police Department in Connecticut and falsely charged with criminal trespass and breach of the peace. All non-violent, baseless charges. These charges are completely baseless, designed to intimidate journalists and activists who expose misconduct. During this arrest, Connecticut State Police Sergeant Bryan Fahey spit in my face, the ultimate act of vile disrespect and abuse of power. Even worse, he physically assaulted me yet again and was not charged yet again. And my bond was deliberately and corruptly raised to an outrageous $75,000 after powerful local officials got involved to punish me. This is very reminiscent of a certain Massachusetts situation that we know of, isn't it? They want to bury me in legal costs so that we can't keep fighting, but I refuse to back down. I am fighting back by defending myself and my cameraman in criminal court against these false charges, filing a federal civil rights lawsuit to hold the Connecticut State Police accountable, and shining a national spotlight on police abuse and intimidation tactics. But freedom isn't free. Your donations will help cover legal fees for my defense and civil rights lawsuit, bail bond costs and fees from these deliberately excessive bonds, travel expenses for court dates and meetings with attorneys, equipment and documentation costs so that I can continue exposing misconduct and educating the public. I am determined not just to clear my name, but to force real change in Connecticut policing. If you believe in constitutional rights, freedom of the press, and holding um, excessive, because I never know what YouTube's going to freak out about. Um, so it starts with A, but I'm going to substitute excessive force of police accountable. Please donate today and share this campaign. Together we can show them that they can't, we the people's rights. They can't what? We the people's rights? I feel like there's a missing word there. But that's okay. That's okay. So people are writing in with words of support. They're making donations. He's so close to his goal, which is fantastic. 1,300 donations have been made. So, I mean, I find this to be very encouraging, right? And hopefully he will keep us updated on how things progress with regard to this. Something tells me it's going to be a lot more than $40,000 by the time it's all said and done. Meanwhile, there's also a change.org petition going around. It's titled Fire and Prosecute Connecticut State Police Sergeant Bryan Fahey. And there are currently 33,394 verified signatures. Let's take a look at the issue here just to see if we can learn anything else about the situation. We, the people, demand justice and accountability for the repeated misconduct of Connecticut State Police Sergeant Bryan Fahey. On July 11th, 2025, independent journalist SeanPaul Reyes and his cameraman were unlawfully arrested by Groton Town Police after Sergeant Fahey assaulted Reyes by spitting in his face and brandishing an unholstered firearm during a confrontation at Fahey's Groton, Connecticut home. This incident, fully documented on video, is part of a disturbing pattern of unprofessional and aggressive behavior by Sergeant Fahey, who has a history of violating Reyes's constitutional rights dating back to 2021. Reyes, a constitutional activist with nearly 1 million YouTube subscribers, as Long Island Audit, visited Fahey's residence to question him about a potential, how are we going to get around this? Um, Taking advantage of overtime. It starts with an A. As Fahey earned over $212,000 in 2024. Exercising his First Amendment rights, Reyes rang Fahey's doorbell and began retreating when Fahey demanded that he leave. Instead of de escalating, Fahey escalated the situation by exiting his home with a firearm, shouting expletives, physically bumping Reyes, and spitting in his face, an act of assault captured on camera. Despite this clear evidence, Groton police arrested Reyes and his cameraman on charges of breach of peace, criminal trespass, and voyeurism, oddly enough, while Fahey faced no immediate consequences. This is not an isolated incident. In 2021, Reyes was unlawfully detained by Connecticut State Police at Bradley International Airport for filming in a public space. Reyes subsequently went to the state police headquarters in Middletown, to inquire about filing a complaint. That is when he first met Sergeant Fahey, and when Fahey slapped Reyes's phone from his hand, a la Jill Daniels, right? In 2023, Fahey forcibly shut a door on Reyes's body yet faced no arrest, charges, or discipline despite internal affairs complaints. These repeated abuses of power demonstrate Fahey's unfitness to serve as a law enforcement officer. The citizens of Connecticut deserve a justice system that holds law enforcement accountable. Sergeant Fahey's actions endanger public safety and erode trust in the Connecticut State Police. We call on Governor Ned Lamont, Attorney General William Tong, Inspector General Elliot Prescott, Chief State's Attorney Patrick Griffin, and DESPP Commissioner Ronell Higgins to take immediate action. And here's what they're requesting: arrest and prosecute Sergeant Bryan Fahey for assault and other applicable charges, fire and decertify Fahey, ensuring he can no longer serve as a law enforcement officer, and strip Fahey of qualified immunity and his publicly funded pension to reflect the severity of his misconduct. By signing this petition, we stand with SeanPaul Reyes and demand transparency, accountability, and justice. No one, especially those entrusted with upholding the law, should be above it. Let's send a clear message that such behavior will not be tolerated in Connecticut, the Constitution state. Sign now to demand justice and protect the rights of Connecticut citizens. So that gives us a solid background of what all has been going on with this um, hyper aggressive Looney Tune. Let's see what his history is in that other case that I was able to track down. Hopefully, you can see this document okay. It is an 11-page memorandum of decision on the motion for summary judgment. It was filed in the United States District Court, District of Connecticut. The plaintiff is Juan Gonzalez, and the defendants are Officer Chad Stringer, Officer Jeffrey Kalalo, Officer Michael Meehan, Officer George Potts, Officer Bryan Fahey, Officer Carl Brisson Lopez, Officer Cornelius Rogers, Officer John Clark, Officer Humberto Morales, and the City of New London. So let's see what we've got here. Okay, plaintiff Juan Gonzalez alleges that the defendants, whose names I just read, violated his constitutional rights. Takes us to the first footnote. The individual defendants are all police officers for the City of New London. The complaint only identifies each individual as an officer. This ruling references the rank of each defendant officer as identified in papers to the unopposed motion for summary judgment. Specifically, plaintiff asserts that 1. Stringer, Kalalo, Meehan, Potts, Lopez, Rogers, Clark, and Fahey violated his Fifth and 14th Amendment right to be free from excessive force and his Eighth Amendment right to be free from cruel and unusual punishment. 2. Officer Morales violated his Fifth and 14th Amendment right to be free from excessive force and his Eighth Amendment right to be free from cruel and unusual punishment. And number 3, the City of New London violated his constitutional rights, onto the second page, through its failure to promulgate and enforce appropriate practices and customs regarding the use of force and through inadequate training and supervision of its police officers. Defendants have filed a motion for summary judgment on the complaint in its entirety. So the officers have filed the motion for summary judgment, and the plaintiff has failed to file an opposition to that motion. Upon review of the merits and absent objection, the court will grant the motion for summary judgment. Oh my gosh, I hope this guy wasn't pro se. Oh, I hope this fellow wasn't pro se. Okay, let's dig into the background. Defendants have filed statements of fact In compliance with Local Rule of Civil Procedure 56A1, plaintiff has not filed any response to the motion and accordingly, consistent with Local Rule 56A1, the court will accept the material facts asserted in the statement of facts and supported by evidence as admitted by plaintiff. On July 28th, 2005, defendant officer Brisson Lopez was on patrol in the city of New London. He noticed a vehicle with its parking lights on, parked across the street from the address of a known heroin dealer. Officer Brisson Lopez observed three males in the vehicle who appeared to be slouching in their seats to avoid detection. Plaintiff was seated in the rear driver's seat of the vehicle. Officer Brisson Lopez radioed to police headquarters that he, quote, would be out with a suspicious vehicle and gave his location. He then approached the vehicle and observed that the plaintiff's right hand was inside the waistband of his pants. Due to his observation of plaintiff's hand position, Officer Brisson Lopez believed plaintiff was trying to either hide drugs or a weapon. He ordered plaintiff and the other individuals to show their hands. After plaintiff refused to comply with his order, Officer Brisson Lopez drew his firearm. Plaintiff finally complied with the order. I'm noticing that the judge is actually using a lot of words that convey bias, even as she recounts the background of this situation, and it's making me very uncomfortable. Okay, page 3. Sergeant Cololo and officers Clark, Potts, Meehan, Rogers, Fahey, and Stringer. How many is that? 1, 2, 3, 4, 5, 6, 7. All right, so 7 officers arrived shortly thereafter. Officer Stringer took out his police canine, Kiva, and told plaintiff and the other individuals not to move or flee. Officer Meehan ordered plaintiff to step away from the vehicle. After searching plaintiff, Officer Meehan found a packet containing 7 grams of cocaine. As Officer Meehan attempted to place handcuffs on plaintiff, plaintiff began to struggle and resist. Officers Fahey and Rogers assisted Officer Meehan, but they were unsuccessful in handcuffing the plaintiff. Plaintiff broke free of the officer's grasp and fled on foot. Officer Stringer yelled that he would release his canine if plaintiff did not stop running. After plaintiff failed to comply, Officer Stringer released canine Kiva. Officer Stringer followed after Kiva while the other defendants remained with the stopped vehicle. Plaintiff struggled with Kiva and sustained several dog bite injuries. Wonder what those looked like, right? Perhaps a lot like the bite of a taillight. When Officer Stringer determined that plaintiff could be detained, he instructed Kiva to release the plaintiff. And, dollars to donuts, it was on the elbow because, those dogs, they love elbows. An ambulance was called to treat the plaintiff's injuries. Plaintiff was taken to Lawrence and Memorial Hospital for treatment of his injuries. He told the hospital staff that he had been smoking angel dust and did not know what had happened. I wonder what angel dust is. I'll have to look it up after. I'll have to look it up in incognito mode after. Um, okay, let's see. Plaintiff was charged with possession of crack cocaine, possession of crack cocaine with intent to sell, possession with the intent to sell within 1,500 feet of public housing, and resisting arrest. On October 26th, Sergeant Potts and Officer Clark observed plaintiff riding in the passenger seat of a vehicle. Sergeant Potts was aware that there was an active felony rearrest warrant for plaintiff. Sergeant Potts and Officer Clark radioed for a marked police car to stop the vehicle. Officer Morales was in the area and stopped the vehicle in which plaintiff was a passenger. Sergeant Potts and Officer Clark also stopped at the scene in their unmarked police vehicle. Officer Morales retrieved his police canine Nico from his vehicle and approached the passenger side of the stopped vehicle. Man, these Connecticut State Police dogs are working hard, huh? Sergeant Potts and Officer Clark approached the stopped vehicle as well. Officer Morales ordered plaintiff to exit the vehicle numerous times, but he did not comply. Plaintiff locked the door when Officer Morales and Potts attempted to open the door to the passenger's seat. Officer Clark yelled to the other officers that he had just observed plaintiff place what appeared to be uh, the the substance in his mouth. Plaintiff refused to comply with the officer's orders to open the door. Sergeant Potts attempted to open the passenger side door by kicking and prying at the window, but he was unable to gain entry. Kicking and prying at the window? That doesn't sound very professional, but okay. The officers observed plaintiff struggle with the driver of the vehicle. Plaintiff reached over the vehicle's driver, started the vehicle, placed it in drive, and stepped on the accelerator. As the vehicle sped off, it hit Officer Clark in the arm, almost knocking him to the ground. Oh, more taillight injuries. And it almost knocked him to the ground, but it didn't. So if something didn't happen, is it even worth referencing in here? That's what I mean by the um, kind of subliminal bias that I'm seeing. The officers followed the plaintiff at a high speed through the streets of New London and onto Interstate 95, I 95. After plaintiff crashed his vehicle into a guardrail between the northbound and southbound sides of I 95, he fled on foot, running across the I 95 southbound lanes of traffic into a wooded location. Plaintiff then hid under an abandoned tractor trailer. Oh, what are the odds, huh? That's convenient. Okay, page 5. Defendant Officer Morales sent his police canine Nico to locate the plaintiff. After approximately 15 minutes of tracking, Nico pulled toward a particular 18-wheeler tractor trailer. Officer Morales did not know whether plaintiff was armed and gave Nico the command to engage plaintiff if located. Subsequently, Officer Morales heard a male voice yell from underneath the trailer, and he observed Nico and a male that he recognized as plaintiff emerge from under the trailer. Officer Morales ordered plaintiff to show his hands. At first, plaintiff failed to comply with Officer Morales' orders to show his hands. Sensing a trend here. However, after plaintiff complied with the order to show his hands, Officer Morales commanded Nico to disengage. Plaintiff was then placed in handcuffs and an ambulance was called to the scene to treat plaintiff's injuries. The ambulance took plaintiff to L&M Hospital where he was treated. At the hospital, plaintiff informed the medical staff that he had used multiple substances that day, and he told New London police officers that he had just smoked PCP. Gosh, it's, you know, I had I'm guessing most of us had the Dare to Keep Kids Off Drugs in 6th grade, so it has been a long time since I have seen a lot of these words, and I don't even know what they mean. Okay, so he had just smoked that and didn't know what he was doing. Thereafter, plaintiff received additional follow-up treatment from the Department of Corrections. Plaintiff was charged with possession, tampering with evidence, assault on an officer, larceny in the first degree, reckless endangerment, interfering with police, does that say trover? Criminal trover in the second degree? We're going to need to look that up after. Escape from custody, failure to appear, engaging an officer in pursuit. See, sometimes the Massachusetts accent sneaks out. Reckless driving and operating a motor vehicle with a suspended license. Discussion. A motion for summary judgment will be granted where there is no genuine issue as to any material fact, and it is clear that the moving party is entitled to judgment as a matter of law, and the case law cited is Celotex Corp. versus Tetret, 1986, only when reasonable minds could not differ as to the import of the evidence in summary judgment proper. And then another case, Bryant versus Mafucci, is cited from 1991. The burden is on the moving party to demonstrate the absence of any material, factual issue genuinely in dispute. American International Group Incorporated versus London American International Corp, a case from 1981. Boy, these cases sure seem old that they're citing, don't they? In determining whether a genuine factual issue exists, the court must resolve all ambiguities and draw all reasonable inferences against the moving party. Anderson versus Liberty Lobby, Inc. from 1986. If a non moving party has failed to make a sufficient showing on an essential element of his case with respect to which he has the burden of proof, then summary judgment is appropriate. If the non moving party submits evidence which is merely colorable, legally sufficient opposition to the motion for summary judgment is not met. When a non moving party fails to respond to a motion for summary judgment, quote, the district court is not relieved of its duty to decide whether the movement is entitled to judgment as a matter of law, end quote. Vermont Teddy Bear Company versus 1-800-beargram.com. Well, that was not on my bingo card for today. It was a case from 2004. If the evidence submitted in support of the summary judgment motion does not meet the movement's burden of production, then summary judgment must be denied even if no opposing evidentiary matter is present or presented. D.H. Blair and Company, Inc. versus Gott Diner, a case from 2006. District courts have granted unopposed motions for summary judgment so long as the movements have satisfied the burden of production. Comes to us from a case from 2010. Due process claims. Plaintiff claims defendant's conduct violated his constitutional due process rights pursuant to the Fifth and 14th Amendments. However, plaintiff's due process claims fail as a matter of law. The Fifth Amendment applies to deprivations caused by the federal government rather than a municipality and its employees. Huh. I didn't know that. Did you know that? That's interesting. I didn't realize it had to be a federal government rather than state or local to be covered by the Fifth Amendment. That's interesting. See Dusenberry versus United States, 2002. Plaintiff cannot maintain a substantive due process claim pursuant to the 14th Amendment based on the alleged use of excessive force because such violation is covered by the Fourth Amendment, Graham versus Connor, 1989. The generalized notion of substantive due process does not apply where Fourth Amendment provided specific protections. Summary judgment will enter. Claims of cruel and unusual punishment pursuant to Eighth Amendment and 14th Amendment. Plaintiff alleges that his constitutional right to be free from cruel and unusual punishment has been violated. The court construes this claim to be based on alleged inadequate medical care. Huh. The court construes this claim to be based on alleged inadequate medical care. That's the cruel and unusual part? That's interesting, and I wonder why the court needs to construe. I would be very interested in seeing the rest of the documents with regard to this case because it seems like there's just a lot of missing pieces here. Okay. The court will grant summary judgment on these claims. As an initial matter, plaintiff cannot maintain this claim pursuant to the Eighth Amendment because his claims concern conduct that occurred prior to conviction. Okay, so, you know, it's it's not a problem if the cruel and unusual punishment happens before you're convicted, right? Like again, this all seems very weird. I am not necessarily questioning the accuracy of it, but it is a very unusual interpretation of what I thought I understood about constitutional law, which I mean, I'm not a lawyer, so the answer of what I understood is not much, but still, like, are you as surprised as I am about these little details and the way that they're being presented here? And they cite a case, City of Revere versus Mass General Hospital from 1983. Eighth Amendment scrutiny is appropriate after state has secured a formal adjudication in accordance with due process. Further, by the way, we're on page 8. Further, no evidence supports an allegation that defendants violated the 14th Amendment due process clause based on inadequate medical care while in custody. Plaintiff must show that defendants violated his due process rights by denying him treatment to remedy a serious medical condition due to their deliberate indifference to that need. See Wayant versus Oxt, 1996. Ooh, gosh. Okay. This reminds me of, I don't know if you guys are familiar with the case of Sandra Melgar, who, in my opinion, was wrongfully convicted for the death of her husband, Jamie, or Jim Melgar. And she, oh God, it is such a heartbreaking case. I encourage you to check it out. I'll try to remember to put a link in the comments, or even like if you want me to cover it, I'd be happy to cover it because it is the most bizarre. Like if we thought that Karen Reed was not guilty, when you look at the Sandy Melgar situation, you're like, "Oh my gosh, like there is no way this woman could have done what they're accusing her of." Like no physical way, no physical evidence, nothing. And the jury convicted her, and the jury foreman was interviewed by the news and he said, "Yeah, the state story just made more sense." And it was like it was a story just like the one that the Commonwealth, that the state cooked up against Karen Reed. Like it was completely fabricated. And now Sandy Melgar is has been in prison for I think the last maybe 7 years. And her poor daughter she's an only child. She has effectively lost both parents. She has been trying so hard to get justice for her mom and to get her mom out of prison. And the reason that I'm telling you all of this is because a couple of years ago, Sandy Melgar apparently broke her leg. She has a number of health problems that would have made it impossible for her to kill her husband, but a number of pre existing health problems, and often uses a wheelchair or a cane or crutches to be able to get around. And apparently, at the prison where she's staying, there are shower curtains that are a problem. They billow, they tangle, they're a tripping hazard. And the inmates had expressed concern multiple times to the um, leadership at this prison that, someone is going to get hurt. These are a serious problem. Something needs to change. We need to replace these shower curtains. And lo and behold, Sandy ended up having a broken leg caused by the shower curtain. And I think it was a broken, I think it was a femur. It's one of the big leg bones. She had to, Sandy, had to manually hold the bones together for hours upon hours before they got her medical care in that prison. So I feel like if this judge is saying that the standard is that the um, the people in the custody of the person are denying them treatment to remedy a serious medical condition due to their deliberate indifference to that need, and I feel like Sandy Melgar would have a claim based on that standard. I mean, between the fact that it was caused by something within the prison, the fact that care was, like, denied for so long, I mean, mercy. It just oh gosh, that case will break your heart. Like I said, let me know if you want me to cover it for you because it is very interesting to see what happens to the Karen Reeds of the world when they don't have an army behind them. And in my opinion, that is what happened in Sandy Melgar's case. So, to continue with where we are here in this article, no evidence raises an inference that plaintiff was not taken promptly to the hospital for treatment of his injuries. Summary judgment will be granted on this claim. And then it says Fourth Amendment excessive force claims against individual defendants. Plaintiff's claims of excessive force are properly reviewed under the Fourth Amendment. Defendants assert that the use of force in conjunction with plaintiff's two arrests was reasonable. In the alternative, defendants maintain that the officers are entitled to qualified immunity. Huh. So this helps us to understand SeanPaul Reyes's request that A, the Sergeant Fahey be held accountable for the unreasonable use of force, but also that he be stripped of his entitled qualified immunity. Because based on this little section here, it seems like that's kind of how um, the bad officers, and I don't think that all cops are bad, but just, the bad ones, the naughty ones, are getting around the excessive force policies. They're saying, well, we're entitled to qualified immunity because of the situation. So, okay. Whether the use of force in a particular seizure is reasonable is governed under the Fourth Amendment standard of reasonableness, which determination requires consideration of the facts and circumstances of the particular case. Graham versus Connor, 1989. Police officers must make split second judgments in circumstances that are tense, uncertain, and rapidly evolving, and therefore the reasonableness of the force applied must be judged from an on scene perspective and not with the 2020 vision of hindsight. Uh, Socher versus Katz, 2001 is that case. Here, the undisputed record reveals that the officers are entitled to the shield of qualified immunity. Under federal law, a police officer is entitled to qualified immunity where one, his conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known, or two, it was objectively reasonable for him to believe that his actions were lawful at the time of the challenged act. Jenkins versus City of New York, 2007. The objectively reasonable test is satisfied if officers of reasonable competence, that's the standard, reasonable competence, could disagree on the legality of the defendant officer's actions. Tierney versus Davidson, 1998. The right to be free from the use of excessive force was clearly established at the time of plaintiff's arrest. Mickle versus Morin, 2002. Generally, where the circumstances are disputed and contrasting accounts raise issues as to the reasonableness of the force, summary judgment cannot be granted on a defense of qualified immunity. In this instance, there are no conflicting accounts presented. Oh, so all the police officers agree what happened. So, okay, no conflict, no problem. Where a party does not respond to arguments made in a summary judgment motion, defendants need only satisfy a modest threshold burden of demonstrating entitlement to the relief requested in the motion. See Rusiniak, Rusiniak versus Gensini, in 2009. Accordingly, in light of the undisputed facts that on July 28th, 2005, plaintiff broke free of the officer's grasp and was fleeing when Officer Stringer ordered him to stop and informed him that failure to comply would result in release of the canine Kiva. Sorry, does the name Kiva sound familiar? Have any of y'all watched the show? It's called America's Next Top Dog. It's on Hulu. It's on A&E, and all these police dogs, and also some not police dogs. They all compete. It's like American Ninja Warrior, but for dogs. It's really interesting. I try to show my goofy golden retriever, like I try to have her watch a few episodes every year to teach her how to be like a good dog, like an obedient dog, one that really is like with it and cooperative. She never takes the hint. But the name Kiva right now is ringing a bell, and I'm wondering if Kiva was on the show. So after I get done recording this, I'm going to have to look and see if Kiva was on America's Next Top Dog. Okay, so the court finds that the release of the police dog was objectively reasonable. Similarly, the undisputed facts establish that defendants' conduct, including Officer Morales's release of the canine Nico, was objectively reasonable on October 26th, 2005. Plaintiff had led the police on a high speed pursuit and was thought to have ingested substances. To the extent that plaintiff advances a theory that any of the other officers, are also liable for excessive force or failure to intervene, the court finds that their conduct was also objectively reasonable. Summary judgment will be granted on plaintiff's excessive force claims against the individual defendants. Now, for the claims against the City of New London, plaintiff alleges that his constitutional rights were violated due to the City of New London's failure to promulgate and enforce appropriate practices and customs regarding the use of force and to train and supervise properly its police officers. A municipality is liable for deprivation of a citizen's rights pursuant to 42 USC, United States Code, 1983. That is okay. When they call it a 1983 claim, such as the ones that hopefully Karen Reed will be able to file, and hopefully Aiden Carney will be able to file, and hopefully SeanPaul Reyes will be able to file. They're calling it that because apparently, I looked this up the other day, um, it is like section or line 1983 in the United States Code. So up until I looked it up, I thought that it had something to do with something that happened in the year of 1983, but that's actually just the line number or the item number in this big long list of different um, claims that are available as remedies. So when execution of a government's policy or custom, whether made by its lawmakers or by those whose edicts or acts may fairly be said to represent official policy, inflicts the injury that the government as an entity is responsible under subsection 1983. Monell versus New York City Department of Social Services in a case from 1978. A municipality may be held liable for inadequate training, supervision, or hiring where the failure to train, hire, or supervise amounts to deliberate indifference to the rights of those with whom municipal employees will come into contact. City of Canton, ironically. Um, Here, there is no evidence of a policy or custom causing plaintiff's alleged deprivation. Summary judgment will be granted on this claim. Conclusion. For the foregoing reason, the motion for summary judgment, document number 26, will be granted. The clerk is instructed to enter judgment in defendant's favor and to close the case. Dated this 4th day of August 2010 at Bridgeport, Connecticut. It is signed electronically by Warren Eginton, senior United States District Judge. And that takes us to the end of the article. All right. The last thing that I want to show you today is something I stumbled across extremely unexpectedly last night as I was beginning to research this case and learn a little bit more. This comes to us from Glassdoor, a source of, it's kind of like an opportunity. It's almost like Yelp, but for employers. So people are able to write and review and express various compliments or concerns about employers so that as other job seekers are out there trying to evaluate what companies would be a good fit for them, they are able to learn a bit more from existing or former employees. And so I found this state of Connecticut review. The title says, "Worked with Sergeant Bryan Fahey and saw him assault people. Bryan Fahey's co-conspirator, State of Connecticut employee review." And it says, pros, learned how to fight people. Cons, now can't sleep at night. It says that this was published on the 9th of April, 2025. Now, because I don't have a membership or an account, I should say, to Glassdoor, I can't see if there is a full review or if this is all there is to it. And I also don't know how Glassdoor works. Like, I don't know if maybe this person already had made a review with the state of Connecticut and, on April 9th. And maybe recently, because of the news, they came back in and edited the title and changed what they had to say. I honestly don't know, but I just thought that it was kind of an interesting comment or title for a review given these recent like transgressions, things that have transpired. So that's what I have for you today. I apologize that it's a little bit chaotic and all over the place because this is an emerging situation and I had kind of limited time today. Usually I try to, plan out what I'm going to say, make it just right, get it organized, but with the limited time that I had today to be able to sneak away to record this, I was like, "Oh, I'll just freestyle. It'll be fine." And I know that that probably created a bit of a chaotic experience for you, and for that I do apologize. But I will commit to continuing to learn more about this. Like I said earlier, let me know in the comments if you're interested in learning more about the Sandy Melgar case, one that is just very near and dear to my heart. Because, like I said, in my opinion, wrongful conviction. And gosh, there was something else I was going to say, and it is slipping my mind. Oh, I'm so sorry. Okay, well, I tell you what, I look forward to our next opportunity to spend time together. Please, if you enjoy this content, first of all, I assure you that it's not normally this chaotic. But second of all, I would love to see you again. So please feel free to subscribe. It would be greatly appreciated if you could give the video a thumbs up. And hopefully, our paths will cross again very soon. And until then, take care of yourself, take care of each other, and take care of our community. I love you.